during this webinar, we'll be focusing on, well, we'll touch a bit about on Burley Law, so meet the team, a bit about Liz and what we do here. And then we'll move on to the importance of hiring well. Then we'll talk about how mission, vision, culture and values impact recruitment. Then we'll move on to compliance, processes, and then finally onboarding and paperwork. So a bit about Burley Law. So Liz is our employment law solicitor. And we also have myself, I'm a paralegal. We have Reese, she's a trainee solicitor, and we have Des, who leads on the intellectual property and commercial side. Our key values are we put people first, we're collaborative, we're straightforward, and we embrace challenge and change. And we're based here in Birmingham, just by Aston University. So I'll hand over to Liz now, who will start the webinar.
So it's afternoon now. Good afternoon, everybody. And we thought we'd be a bit festive today and have a little bit of tinsel on our banners just to get in the festive swing of things. So the importance of hiring well. I am going to linger on this a little bit because it really does set the scene for what we go on to think about in terms of good recruitment frameworks, processes, compliance, paperwork. It gets us thinking about why we need to invest time in this as an area of our HR practice. Although I'm an employment lawyer by trade, a lot of what I see in my day-to-day practice and have seen over the years can sometimes be traced back to poor recruitment habits, policies, practices, paperwork. Things that you see on the screen here are typically things that have developed and got out of hand, escalated, and end up with a lawyer because they haven't been managed from quite an early stage. And that can often mean right from day one, unfortunately. So I'm particularly thinking about poor performance. And sometimes minor misconduct, low-level stuff that happens and isn't nipped in the bud, rather than the gross misconduct type of thing. Sickness absence, or the impact, we can look at that as well as the impact of health issues in day-to-day work and on relationships and on the performance of the business. Grievances, often spring out of, develop out of these attitudes that can be prevalent from day one and that aren't managed in the right way. And all of these things sometimes could have been picked up, identified as part of recruitment practice and onboarding of new staff. So the impacts can be quite high and significant if this stuff gets out of control. There are things that can be difficult to manage, as I'm sure we've all come across in our working lives. Grievances are very time consuming, so are disciplinary matters. Poor performance is incredibly difficult to manage well, and sickness absence can be paralysing for a business. Sorry to use that expression, but it is, you know, it's very disruptive and it's very uncertain. There's no endpoint often with short-term and long-term absence. So it's very difficult to bring to an end successfully for a business. These things have a direct hit on management time in terms of the cost of the time to deal with them and the distraction from doing what managers should be doing, which is managing and growing businesses and dealing with operational matters other than HR. They impact other members of staff directly and indirectly. And at the end of the day, they slow down your service delivery and the quality of what you're doing as a business. And that's detrimental to the business future. So we're going to move on to the more positive side of why we should place importance on recruiting well, getting the framework right and the process in place. This is the good stuff. These are the good impacts of having good recruitment. If we get the right people into our businesses, they will have an exponential impact on our business growth and on the future development of the workforce. We know that SMEs make up 2/3 of the UK workforce. 2/3 of the UK workforce work for SMEs. SMEs are the growth engine of the UK economy. And people, despite what all the AI scaremongers tell us, people are still pivotal to the growth of business. Technology can only do so much. If I was sitting here in 50 years' time, maybe that wouldn't be me, it'd be a robot and everything would look very different. But in 2023, the importance of people to business is still critical. Now, we know that with growth comes other challenges, hiring quickly, maybe the bad fit, short-termism, and there can be some difficulties that come out of that. But getting the right people in place and managing them, developing them well, keeping them engaged and retaining their skills and their cultural and value fit to our businesses can accelerate, can galvanize growth, can rocket fuel the growth of our businesses. So these are the good positive impacts of why this is important and why we should be thinking about the steps we need to take in a proactive manner, not reactively. So going on to the next slide. How can we identify these star performers, the people that are going to make this difference to our business and help us grow our operations and our workforce? So for me, it's about 3 things that need to be very clearly identified and put in place before we go out to the market to hire anybody. Priorities. Why do we need to recruit? What do we need to recruit, and who do we need to recruit to our business to ensure success? Now, your priorities for your business, and you'll all be from different businesses, different sectors, different maturity of businesses, different stages of your growth journey. And those priorities will be different depending on what your business is doing and where it is at. For an early stage, found a business, and we deal with a lot of them in our day-to-day work. The priority may be on hiring a very key player who will lead and develop the strategy to bring a product or a service to market, to create a proposition, a business proposition that is going to create value and attract investors. For a business experiencing operational growth, that recruitment priority may be very different. It may look like hiring for operational and product delivery. So it might be more technical skills and attributes that are needed. And there may come a tipping point in the maturity of the business where the commercial functions require leadership that's more professional. So we might be thinking of FDs, HRDs, commercial directors, strategic directors, marketing directors to head up functions which are delivering in those areas. So what the priorities are will be very context specific to your business and where it's at and what it's doing and the direction that it is going in and the plan for the next 12 months, 3 years, 5 years. Now, the process is the key steps that you need to take to ensure successful hiring, but also legal compliance. So we've got one eye on making sure that the business is protected from possible legal claims. And the paperwork that you need to have in place will depend on the stage of the recruitment process, different documents for different stages, and we'll come on to look at that in a few moments. I mean, in essence, I think there are 3 things, and the expression you may have heard of, three types of people that businesses need: finders, minders, and grinders. And they all have different roles in your business. And in SMEs, those are people that will be very key to moving the business forward. The finders who go out and hunt for the work, who create the opportunities, who are strategic in the marketing areas that your business needs to perform, the people who create the business, the pipeline. the grinders who make those things happen, who are key in maybe putting into processes the things that need to happen to deliver the pipeline of work that you create. And the minders are the people who will very successfully get on with it and deliver on the ground. So very different types of skills needed for each of those functions, but in essence, that is what each growing business will need. More of some at different stages than others, and the requirements may change over time, as I've said. And moving on, we're going to look at mission, vision, culture and values and how they impact the recruitment process and why you should have them in mind.
So let's take it back not a few years ago, let's say 30 years ago, mission, vision, culture and values were not really considered during the recruitment process. But now, as generations have gone on, now we're looking at Gen Z entering the workforce, things are really different. They're looking at how companies' ethics and values align with their own, whether they can work here. And I think people of the earlier generations today are not afraid to move on if they don't find the company they're working for fits them. So employees, they have higher demands and higher expectations. As I said, they're looking for somewhere that works with them, where they can see themselves fitting in. And things like long service awards are no longer handed out as frequently. If a company doesn't fit within what an employee is looking for, they'll happily move on and enter into something different. And recruiters are already looking for talent within a limited pool of candidates. So having realistic mission, vision, culture, and values are important to help them stand out and attract the best talent. Having unrealistic, kind of generic mission and vision statements on websites just makes businesses look like every other company out there, and especially when candidates are applying online and you see the standard, how do you think you'd fit into our company? Having realistic and unique mission, vision and culture can help you find someone who is actually going to fit in with you, rather than people just giving generic kind of standard answers that they can put for any other company because everyone else has the same mission, vision and culture.
Thanks, Isha. So I'm going to move on to think about some compliance issues now, as you'd expect me to do as an employment lawyer. And in employment law terms, the main claim that you would need to have in mind for protection for your business in a recruitment process is going to be discrimination, because this is the claim that any job candidate can bring against a business that is running a recruitment process. So to bring a discrimination claim, an individual does not have to be an employee of your company. They can be somebody who applies for a job and who is rejected on paper. They can be somebody who attends an interview and has been shortlisted and then it is rejected. They may be somebody who's offered a job with you and then the job offer is withdrawn. So at any stage of your recruitment process, you need to be aware of the possibility of a discrimination claim. And that can be a frightening prospect, and it can be very hampering, because you think, well, it doesn't really matter what I do. I'm damned if I do, and I'm damned if I don't. But I would encourage you to think about discrimination from a completely different lens. And the lens I like to encourage is one of thinking about fair and objective recruitment frameworks, which will identify the best candidates for your business who can deliver the outcomes that you are looking for. If you steer away from subjectivity in your process, whether that is in the job description that you create for the role, the person spec, the selection process and criteria, the interview questions, and the decision making, if you keep fairness and objectivity in mind throughout those key steps, you should not have any fear of discrimination claims against your business. And the other key thing to go hand in hand with this fairness and objectivity you have in mind is the importance of record keeping. I've done a lot of employment tribunal work over the years, and I cannot begin to emphasize enough the importance of robust record keeping for HR processes, whether that is in connection with your recruitment or your day-to-day HR management of employees and the administration that goes alongside it. Often, employers think of good HR admin being record keeping about holidays and sickness forms, sickness absence and pay, but they often fall down in relation to keeping records of meetings and interactions with people. Now, nowadays, with everybody being used to communicating through email and other digital formats, this is not so much of a problem as it used to be when everything was done on paper, but it still catches businesses out when they are having face-to-face meetings or online meetings, as can be the case for recruitment. So think very carefully about what records you will need to capture your decision making, the reasons for recruiting to this role, the type of skills and attributes you're looking for, your shortlisting decisions, and your decisions about who to offer and not to offer the role to. So discrimination can crop up in relation to any of the things that you see on screen, because under the Equalities Act, the wording around discrimination is that it can arise, it can happen in relation to the terms on which employment is offered, the terms of the job offer, the arrangements for deciding who would be offered the employment, and in relation to decisions about not offering employment, so that you can see from that legal language all of the stages of the recruitment process are relevant to discrimination law. And there are 9 protected characteristics under discrimination law. We hear a lot about some of them, and maybe not so much in the news and the media about others. So we must have in mind all of those protected characteristics, because people from all walks of life will probably apply to work for, in the role that you advertise. We cannot rule out that people from lots of different backgrounds with different challenges in their lives will apply to work for us. We live in a very diverse society, so we cannot turn our face away from the potential for discrimination. We hear a lot about unconscious bias as well as conscious bias taking place in recruitment decisions, as well as in other aspects of HR management. We need to be aware of unconscious bias and, if necessary, talk to people about how that might affect our recruitment processes. External advisors, training for our key decision makers, our recruitment managers, on what unconscious bias means and how it might play out in our recruitment frameworks, so that we make sure that we are protecting our business, but also operating the most diverse and open and fair and objective processes that we can. There are 4 types of discrimination, which you see on the screen. The most common, I would say, that you're up against in a recruitment process is indirect discrimination. And that's the most subtle, because the other forms are really quite blatant. Direct discrimination really means what it says. You're directly being very unfair or either through words or actions to somebody who has a protected characteristic, and you're doing it because of that characteristic. Harassment is the same. You're making somebody uncomfortable. You're creating a hostile atmosphere, or it being intimidatory because of a protected characteristic that a person has. And victimization is very specific and relates to something that you do because somebody's complained about harassment or discrimination. So I would say keep your mind on indirect discrimination. This is about having in place policies, rules, practices, requirements that people have to meet in their day-to-day work or in relation to applying for a job. Now, I'm just going to quiz you for a moment. If you're able to pop answers in the chat, I'd be really grateful, and Isha will keep an eye on those for us. I'm going to ask you what you think, what kind of protected characteristic you think might come into play by having some of these requirements or references in job adverts or job interviews. So what protected characteristics, what discrimination do you think is at risk here? So if you're conducting a recruitment process and you tell candidates in the job advert or the job pack that interviews will take place in an evening on a weekday, what do you think, looking at those 9 protected characteristics, which ones might be affected negatively by that requirement in the process? You can put your answers in the chat. Just a one-word answer will do. We've got gender, disability. And by the way, none of your answers will be stupid or wrong. I'm just interested to see what you make of these requirements. Gender. So interestingly, we use the term gender a lot in everyday language now, but the language of the Equalities Act is sex. So I'm not going to get into any other conversations about gender, but the language of the law is sex discrimination rather than gender discrimination. And the word gender is used when we describe gender reassignment discrimination. So gender and disability for that one. Yes, neither of those are wrong answers. People who have children and do the child minding, the childcare, are often women. Statistics show that, and they may well be affected, disadvantaged by an evening interview process. What about young and energetic in a job advert? We need somebody who is young and energetic. Who might that affect or disadvantage? We've got age, disability. Excellent. Yes. Clearly for older candidates, the idea of being energetic, and I can speak from experience now as I'm in my mid-50s, energy levels may not be in full supply. And I think using the words, it's quite clear that using the words young and energetic would be age discriminatory and could be challenged by an older worker. And what about after work drinks will be part of the selection day? If we write that into our job spec, our job advert, our recruitment process, after work drinks will be part of the selection day. Got religion and belief appearing. I think that's right. Clearly, in some religions, alcohol is not allowed. It's not habitually drunk. It's not part of socializing, and it would be unwise to make, I think, particularly, I think we have to think carefully about the diversity within our setting. Where are we recruiting? And if our demographic, our pool of candidates is particularly ethnically diverse, religiously diverse, we would think very carefully. I think we'd be wise to think very carefully about making our selection processes inclusive of those different cultures. Interesting. Alcoholic drinks wasn't mentioned, but in a cultural sense, drinks after work in typical British culture, I think connotates alcohol being involved. So it's a good point. Drinks might mean soft drinks are available, but I think we have to have that in mind. Make sure that we're catering for all cultures. And what about one last one? Russell Group universities only. Russell Group universities only. Apologies if you're not familiar with the UK education system, but Russell Group universities, you can Google a particular group of universities considered quite prestigious within the UK education system. I think this is a bit of a posing question because not many people are typing. So that's interesting. Race is mentioned. I think that's yeah, I think that's definitely plausible. This could be race discriminatory, although I think it's a little bit more obscure and difficult to prove. But I think as an indirect discrimination claim, if it could be shown that fewer, for example, Afro-Caribbean students go to Russell Group universities, there may well be a race argument there. There could also be a disability argument. We know that universities have opened up considerably in their access to learning over recent years because of COVID, but also for diversity. And I think it's less likely that disabled candidates would be disadvantaged from accessing learning with those universities, but it's not out of the question. And I think we might also think of people from other religious backgrounds as well, not having access to those universities if they've come to live in the UK and been educated in other countries. So there are lots of other things to think about there. Older workers who didn't have a university education may be disadvantaged by that. And so in all of these things, we are trying to identify where the subjective might intersect with discrimination law and might come up against a problem. And I'm going to come back now to my earlier suggestion that in all of our recruitment steps, we need to be thinking about fairness and objectivity. And if our subjective requirements for the person are filtering in to our job description, our person spec, our recruitment selection activity, whatever that might be, requirements, then I think we're moving away from the fairness and objectivity that we're seeking to put into our process. And having at least two sets of eyes on our recruitment process is sensible, because in that way we get a sense check of whether we our own lens that we see these steps through and the requirements we're putting in, whether it is in fact as fair as we think it is. So I would suggest making sure that recruitment isn't just left to one person is sensible from the point of view of discrimination, and making sure that subjectivity is not leaving the business at risk of discrimination arguments. So we spent a bit of time on discrimination because it's important, and I think in relation to the culture and fit and values that and the impact of those that Isha talked about, many people from particularly the Gen Z, you know, those up to the age of about 25, 26, that pool of candidates who we are looking for to be our workforce for the future, they're particularly exercised, they're particularly keen to look at whether the employers that they're looking at, whether they're considering applying to, would be fair, diverse employers and inclusive employers. And if they sniff out a lack of inclusivity, a lack of objectivity, a lack of opportunity for all, they will not want to come and work for us. I think that's very clear from things that are happening, that we see in the press now around diversity and inclusion and whistleblowing. What the Gen Z workforce is and isn't prepared to put up with in the workplace and in employment practices. So we're going to move on from discrimination now. We're going to think about a little bit about health conditions particularly. Now, disabled candidates have the right to be given opportunities to work, and that's very clear in the Equalities Act. And the arrangements that you make for advertising, shortlisting, interviewing and offering jobs must not discriminate against them. This has led to employers thinking that they cannot ask anything or make health relevant to any employment, and I think that's a misconception. But what is very clear under the Equality Act is that you should not make inquiries about a candidate's health during a selection process, during an interview, before an offer has been made, unless their health and fitness to work is relevant and critical to the job that is being advertised. So if they are applying for a job as a driver, they need to have a driving license, and if there is any health reason why they cannot get a driving license, or there's a health condition on their driving license, then clearly that would be relevant, as would be the physical fitness of a sports instructor who is required to teach circuit training or other physical classes. So you would need to know that they're physically able to do those things. But if the job being advertised is not one that requires physical fitness as such, it's done using technology, it's a thinking job, then the questions about health will be less relevant and not justified in the selection process. And only after the offer has been made would you be justified in asking about health conditions which might affect their day-to-day work, and only then you should be asking them for the purposes of identifying whether the employee will need reasonable adjustments made to their work arrangements or their physical environment or in other aspects of the job. So no questions during interview unless it's critical to the role, in which case you would make that clear in your advert. After the offer has been made, you ask if they're able to, if there are any health conditions that are relevant that you need to know about, and only then for the purposes of identifying reasonable adjustments. Moving on. Just a word about compliance and record keeping at this stage. So I've said that it's absolutely critical that you keep robust records of all of the stages of your recruitment. But how long should you be keeping those records for? Because as an employer, you have to have one eye on the UK GDPR, data protection law. Now, we all know about GDPR, but we don't necessarily know what it means for employment records. So the UK GDPR says that any data regarding employees, any identifying data that identifies them as a person, whether that's their employment contract, their offer letter, their CV, record of their interview, correspondence with them about the recruitment process. Anything that identifies them as a person is their personal data, and that personal data must not be kept for longer than is necessary. Now, that's a very wide and vague expression, and it's deliberately wide and vague because no longer than is necessary will mean different things for different records. So there are two things about data protection law. You need to have a lawful purpose for keeping data, storing data, processing data, using data. And you must, there are other conditions around the use of data, about keeping it securely, who you can share it with. But the retention of data must be only for the purposes that you're using it for, that you need it for. So in an employment context, and specifically for recruitment, keeping recruitment data, the types that I've already described, will only be necessary for the purposes of making the job offer and then retaining information about the employee that you will need to carry out their employment, to manage their employment. So that will mean payroll data, banking information, their name and address. It will mean details of the job that they do. CVs and recruitment selection and all of that jazz, you don't necessarily need to keep. but often poor housekeeping means that this kind of stuff does sit on computers, or in the olden days in office filing cabinets, for quite a long time. The risk of keeping these records for longer than you need them is that you might decide to look at them one day. You might make decisions in the future by reference to what's on a CV, when actually that CV should not have been kept in the first place. So for longer than is necessary in the recruitment process probably means, in the relation to most of that information, only as long as an unsuccessful candidate would have to bring a claim against the business in an employment tribunal. And that period of time will be 3 months from the date you make the decision not to shortlist them, or not to invite them to interview, or not to offer them the job after the interview. After 3 months from that date, the candidate will struggle to bring a claim in the employment tribunal. They might be allowed if it's a discrimination claim, but that's up to the tribunal. So long stop date, I think, should be no more than 6 months. Time for that claim to be brought against the company, and if the tribunal decides a little bit longer can be allowed, then 6 months would be more than sufficient. In any other case, I think it's going to be very difficult to demonstrate why you keep those records for longer, unless you need them to put into place the employment of the successful candidate. So, moving on. Immigration and visas is an aspect of compliance for recruitment processes that applies to every employer. So every employer has a legal duty to make sure that their employees has the right to work in the UK. There has been a clamping down by UK Border Force and the Home Office on right to work checks, and if you do not carry out the appropriate checks, which you must be aware of for any employee, regardless of the size of your business, you could be fined up to £20,000 for each illegal worker if you fail to carry out the right checks. If you knowingly employ an illegal worker, so you know that they don't have the right to work in the UK, but you go ahead anyway, that can be a jail sentence of up to 5 years, as well as a hefty fine. So you need to take professional advice from the right people on visas and immigration. If a candidate comes to you needing a visa, then you must understand what your obligations are in relation to sponsoring that visa, what process needs to take place, how costly it's going to be before you can consider your position as a business and whether you can employ them. And if somebody has a visa but there is some evidential problems, then you must take advice from an immigration expert before going ahead with that employment. Otherwise, you're at risk of these punishments that I've outlined. And the minimum pay requirements, as we all know, are going to change for immigrant workers in April 2024. There are thresholds for different categories of skilled workers. You need to be aware of what those are. Please don't get caught out by taking one figure and applying it, thinking that you are paying the right figure. This is a very complex area of law, and it's only going to get tightened up more as we go forward, because we know that the government's intentions are clear on that. So, a word on your recruitment process, and hopefully we've started to touch on this already, and you've got these things in your mind now because of the things I've been saying already. Preparation. What are we looking for? So I think the 2 bullet points there should be the other way around. Sorry, apologies for that. Our starting point should be our job description, and then what type of person do you need? The person specification. In both of these, we should be focusing on outcomes of the job, not the type of person we want. Outcomes for the job, then the skills needed, both technical skills and other skills, so attitude, cultural fit, the values that our businesses that are important and that drive our business forward. So all of those will need to go into either or both of the job description and the person spec before you even start looking around as to where you're going to source candidates. Then in terms of sourcing, looking at where the job will be advertised, whether you go internally first before you look at external candidates. Thinking very carefully here about our different generations. So our Gen Z people, where are they looking? Are they going to be interested in purely looking at LinkedIn? Will they be the kind of people that will be interacting with recruitment agents? Or will they be more interested in Instagram and TikTok? Will they be really keen on some personal interaction as opposed to just doing everything through social media platforms? These are indications that are coming out of research about what Gen Z are looking for now, and how you can appeal in a different way to and stand out as an employer brand to that particular demographic. And then what about millennials? What about the older workers, the Generation X, like I am? Where are we looking for jobs and how do we want to be interacted with? That'll be different again to our younger workforce pool. Screening and the use of AI, if you're into that, if you're using recruitment tools where AI is driving the shortlisting, you need to be aware of potential discrimination. You need to have human eyes on that shortlist and not just rely on the technology to make the decision for you. Because if you only look at AI, if you only look to the technology, you will be hard pressed to show that your decision on the shortlisting was justified. So human eyes on any shortlist. Working out your interview and assessment days and what they're going to look like, and the assessments that are going to be key to effective and successful hiring for that role. And a lot of thought needs to go into these assessments. If you're going to think about the best fit for your organisation, not just in terms of skills for the job, but the future of the organisation and how the person that is sitting in front of you or doing the test, how they will contribute, the impact that they will make to the long-term success or the medium-term success or the short-term success of your company is absolutely fundamental. So a lot of work needs to go into the selection piece. Your job offers, a word to the wise on job offers, on compliance. Please avoid verbal job offers. If a verbal job offer is made, it needs to be very clear when it's made that a written job offer will follow to confirm the offer. And that written job offer needs to be very clear about its terms, whether they're conditional upon, for example, the right to work check being provided, whether it's conditional upon any medical checks or health questionnaires, whether it's conditional upon proof of qualifications or references. So job offers need to be carefully handled. The law of contract will say that if a job offer is not conditional and you add a condition on later, it's too late if it's already been accepted. So think about making sure that your job offers are extremely clearly worded and that they're consistent. That if you're standardizing your process to streamline your recruitment, that you have documentation that's consistent at every stage, including the job offer. And onboarding. So we will come on to employment contracts in a moment, but two key aspects of your onboarding process that I think you need to have in place before you even go into your recruitment process is your employment contract and your induction and training processes. So what is going to happen on day one and thereafter? So are we moving on to our breakout room for a few moments? Isha's going to take over now and talk you through what you'll be doing in your breakout room.
So we've got a little case study here. It's about Sarah and a job she's applied for at Rosie's. The facts are on the screen, and what I'm going to do is pop everyone into breakout room to answer the question that is at the bottom. So what can or should Rosie's do next? So I'll just whiz through what the facts are. So Sarah applied for a job at Rosie's. Part of the application process included completing an online application form. Sarah struggled with written communication due to her dyspraxia, which is a condition which affects movement and coordination, and she was too anxious about completing the form. She asked to complete the application form verbally instead and explained her condition to Rosie's. Rosie's responded and asked what the specific issue was with completing the form. And then Sarah, in response to that, she didn't respond because she was too anxious about being humiliated, as this is what had happened before with previous employers. She just repeated her request to make an oral application form. So what can or should Rosie's do next? And I'll just pop everyone into a breakout room. Just give me 1 second.
How long are they going to be in the break?
And you'll have between 2 to 3 minutes, because I'm just conscious of time.
Quick fire.
Yeah.
Okay.
So okay, so it's just assigning. Okay, perfect. So everyone will be in a breakout room now, and I'll just open them. Conference room, you can't be put in a breakout room. I'm not sure why, but could you just discuss amongst yourselves? But yeah, so everyone should be in a breakout room now, and then I'll close them in 2 to 3 minutes.
It says 10 seconds.
Oh, perfect. Okay.
We're back.
Yeah. So did anybody want to offer anything that they spoke about in their groups? You can just pop your mic on or raise your hand.
Is anybody bold enough? Okay, well,
That's fine.
That's fine. I will talk about what we said in our group, and if you've got any comments you want to put in the chat, that's absolutely fine with us. So we said in our group that, and I didn't give everybody the answer, this was what the group came up with, that the Roses would be in trouble if they did nothing here and just said no, because the disability law says that employers must make reasonable adjustments for disabled candidates as well as employees. By simply not even considering an adjustment to the process, the employer would not be able to defend a claim for indirect discrimination or failure to make reasonable adjustments. Now, the request for an oral application form could mean simply talking somebody through and verbally giving the information. It could be somebody helping them to fill in the form, but doing so online with them, with the form on screen, and again, going through the verbal information instead. We said that is it relevant? We asked, is it relevant to think about what the job involves that this person is applying for? And we said that might be that if it's critical that somebody's able to complete forms because they are, for example, in a call centre where that's the nature of the job, then maybe. But if there might be a reasonable adjustment that could be effective to allow somebody with dyspraxia to do that job, but with assisted technology, and if that adjustment isn't considered, then again there could be a claim for a failure to consider a reasonable adjustment in terms of the decision not to offer employment. So this is a tricky one. And what I can tell you is this was a recent employment tribunal decision, a real life example of a recruitment process that did go wrong. And the employer was held to account. And just saying no to a verbal application was not enough. The employer should have gone further. And maybe if the application had been done verbally, the employer might well have shortlisted. They might not have done, but by not even contemplating taking that step, they were unable to show a tribunal that their actions were justified. So we're going to go on to think about onboarding a successful candidate now, where you have, we're just moving on to the next slide.
Is it on that one?
Oh, sorry. Yeah, I've got it on mine. So where you have identified your successful potential star performer and you're offered the job, it's been accepted. What next? So all employees must have a written statement of particulars of employment by day one, not by the end of the first month, not by the end of the second month, by day one of employment. And those particulars must set out certain things that you see on the screen. Now I'm focusing on employees here, but this also applies to workers. So people who come to work casually in your business, they may be on what you would think of as a 0 hours contract, somebody who you don't employ, who comes to work for time to time, maybe on projects, maybe on your social media. So somebody you don't consider to be an employee, but you pay through your payroll, could be a worker who needs one of these sets of terms and conditions. So make sure that you are giving them to workers as well as employees. So the basic things that they need, that need to be put in that contract, we would typically call terms of conditions a contract of employment. It could be set out in a letter. It doesn't have to be a formal contract document. It could be set out in the offer letter if you want to be as formal as that in your offer, or it could follow the employment offer once that's been accepted. But if your employment offer says that does not set out the full terms of employment and those are going to follow afterwards, be sure that the letter says that. So all the things you'd expect to be in an employment contract are usually covered, are requirements of the Section 1 particulars. On the right-hand side of the screen, there are some things that are not required by law in particulars of employment, but they are things that you absolutely must consider having in any terms and conditions of employment, or what I refer to as a contract of employment. Why should you have these things? It's because they protect the business assets. So the first thing is confidentiality, clear confidentiality obligations from your employees to the business. If you don't have contractual, clear and comprehensive confidentiality obligations, you will have to rely on the fallback common law confidentiality. And that is less favourable for you as a business. Employees will owe you less obligations on confidentiality, and only during employment, not afterwards. So the purpose of having contractual provisions is to make sure that your confidential business information, whether it's financial, it's customer databases, it's trade secrets, it's pricing information, whatever it is, it's protected both during their employment and afterwards. Now, restrictive covenants, which are the third thing on this list, go pretty much hand in hand with confidentiality. They are contractual provisions that limit what your employees can do after they leave their jobs with you. So after they're finished, they're not employees of yours anymore, you can control their activity if and only if you have restrictive covenants in their contract of employment. Now, restrictive covenants are they are a restraint of trade. They stop people from working in particular ways with maybe your customers, your suppliers, and maybe even from contacting your employees who are still with you. So they limit people's behaviour, and they are known as a restraint of trade. So you have to be careful to draft restrictive covenants in a way that they would be enforceable in a court of law. And that means they need to be tailored to the role that the employee carries out for you, and they must go no further than to protect legitimate business interests. So a restrictive covenant that says you may not work for a competing business, we're in the logistics trade, you may not work for any logistics company throughout the UK for 12 months after your employment ends, would not be enforceable. It goes much further than is necessary to protect your business interests. So it's very important to have the role in mind and what are you trying to protect and how far can you go. Garden leave would be relevant if your employee is leaving and has either been given notice by you to leave or has resigned on notice. So their employment is coming to an end, there is a notice period, and that notice period can either be worked or they can remain on garden leave throughout some of it or all of it. If you are trying to protect key commercial relationships, business interests, suppliers, customers, employees from being poached by your leaving employee, then you would be sensible to consider putting them on garden leave, restricting their access to company systems and assets and relationships. And the other point on here is around intellectual property. It does no harm to say in your contract of employment that all intellectual property created by that person in their job in the course of employment belongs to you as the business. That is the standard legal position, but it is a good idea to make sure that employees are aware of that. We live in an age where people work on multiple devices in different places, and they may think that something that they create in their role belongs to them because it's on their personal computer. That is not the case, and their employment contract needs to state that very clearly. So moving on, background checks. I know that we're running late and I apologise for that. I'm going to rattle through the last few slides very quickly and then we'll be done in about 5 minutes. If you have to leave now, that's absolutely fine. And sorry that we've run over, but we will be posting a recording of the webinar very soon. You'll be able to catch up on the rest of it then. So onboarding and background checks. We've talked about the right to work checks, which is a legal obligation for all employers. Beyond that, nothing is required. It's up to you what background checks you do on your candidate, whether you ask employers for references, whether you carry out any medical screening or ask them to complete health questionnaire, whether you may need them to have a DBS check if their work involves some aspect of safeguarding, or if your suppliers require DBS checks. Those who work in education will be familiar with this. Whether you require any due diligence around their qualifications, professional or technical. So, a word to the wise about checking references. There is no legal obligation on any employer to provide a reference for a previous employee. If they do, it must be fair and accurate and not misleading. It's for that reason, and because a lot of litigation around references that have been unfavourable and stop people from getting jobs, that most employers now have a policy of giving only factual references. That is the name of the employee, their role and their dates of employment. Very few employers go beyond that, and you should not see a factual reference as a negative, something negative about that candidate. It really is for you to do your due diligence through your selection process and your shortlisting and your interviewing to understand whether this person is a good fit for your business and has the qualifications and the experience and the attitude that they say about themselves. It's for you to check that out, not to rely on their previous employer. So onboarding and paperwork, I'm not going to labour on this because we're going to look at this more in our retention webinar, which is coming up in January. What happens on day one? We need to be ready with a training plan, a development plan, an induction for the employee, and we need to consider always disability and reasonable adjustments. So we'll come on to look at that next time. And I want to finish by thinking about probationary periods. Most employers that I've ever dealt with have not really thought about probationary periods and why they're important. And yet, every employment offer, every employment contract that I ever see has a probationary period in it. A probationary period is part and parcel of onboarding an employee, and it should be treated as such. So it should be referenced in the employment offer and in the terms of employment, and it should be very clearly set out in the employment contract if that follows the job offer. So it's a period of time at the start of employment that can be as short as a month, as long as 6 months. Very rarely does it go beyond 6 months. But it needs to be a reasonable period of time that enables you as the employer to assess the suitability of this person for the role you've offered to them and their ability to do the job. Do they shape up to the person they say they are and the person you think you've hired? It's critically important to use the probationary period well and not to wait until the end of it to tell somebody that they're not up to the job. For lots of different reasons, mainly around discrimination law, it's a bad idea to tell somebody on the last day of their 6 months probation that there is a problem with their attendance or their attitude, their ability to work productively, or some other aspect of their performance. So the key recommendations are regular reviews throughout the 6 months or 3 months or whatever it is. At least once a month, probably more intensively in the first month, checking in, assessing work and identifying any concerns and what you're going to do about them, what the employee needs to do about them. When you come to the end of the probationary period, the other key recommendation is have a probationary review at the end. If there is an ongoing problem that has not improved, then you are at liberty to terminate, and usually on shorter notice during a probationary period. So it may be a week as opposed to a month, for example, if that's allowed under their contract of employment. But you're also at liberty to extend the probationary period for a reasonable period of time to further assess. but do not keep continually repeating the extension. Do not go on and on so that you get to over 12 months of employment and somebody is still under a probationary period. Be very clear about when that's going to come to an end and what will happen if the improvement isn't in place by the end of the extension. So regular reviews, is training needed? Is notice during probationary period in your contract? Is it clear that it's a shorter period of notice? And is there an outcome meeting lined up for when probation ends? And again, critically important is the record keeping around the management of probation, so that if there is any blowback from the disgruntled leaver that you haven't kept them on, you have a clear audit trail of exactly what happened during their probationary period. And that brings us to the end. 10 minutes over, so again, apologies for that. A very busy session. I hope it's been useful for you and given you some food for thought. I'd like to thank you for being with us today. I'm going to hand over to Isha to tell you what's coming next in our webinar series.
So if anyone has any questions, you can just pop them in the chat or raise your hand. But as Liz said, these are just our contact details if you want to get in touch. As I mentioned at the start of the webinar, we also do intellectual property, commercial, data protection and tech law. So if you have any queries about that, get in touch and we'd be happy to have a call with you. And then the next webinar is going to be on the 17th of January. And we'll be looking at retain. So you'll learn about how to develop people, make sure that performance stays on track and how to keep your star performers. And then our last one is on 14th of February. So if you don't have plans for Valentine's Day, join us for release, which is our last one. And here you'll learn about how to plan for the worst case scenario and manage processes and legal risks when things don't go so well. So if anybody has any questions, just get the chat.
So we did have one question in the chat, which is around employer sponsorship. I don't know if Ian's still here. I can see he left the chat, so I don't know if he's still on the call. Oh, hi, Ian. So can not offering to sponsor or offering to get a visa for candidates cause discrimination problems? I think the broad answer to that is yes, but as in all discrimination cases, it's a matter of what would you be asked to do as an employer, and is it something that you can a cost that you can bear? Is it a length of time that is you can wait, because these processes aren't quick. We have experience of this ourselves, and sponsorship can take anything from 3 to 6 months. Is that the reason that you are not offering the role? If it is the reason, is it objectively justifiable? And that is the broad legal test. And what is objectively justifiable depends on the context and the facts of the matter. So it's very difficult to say yes or no. It would be a good discrimination claim, but potentially yes, it can be. And the discrimination would be about around race discrimination.
Can I ask a question on that?
Yeah. Is that Robert?
We've been involved in a visa application process for an engineer, and the only way we could go through the process is if we can justify that we couldn't find somebody in the UK with that experience. So ultimately, you don't have to go somebody with a visa, because only if you've got no experience in the UK for that role. So I would have argued that there's no discriminatory case against it, because you're not allowed to go to a visa case unless you've got justifiable cause.
Yeah, and I think this is going to get tighter as well, as we see the government's move towards clamping down now, increasing the salary threshold. They're going to make it more difficult through the visa routes. As an employer, you have to show that you have offered the job to the best candidate for the role. And if the best candidate for the role is a UK based employee who's got the right to work in the UK, that you shouldn't have any fear of a discrimination claim. So that's about who is the best fit for the technical and other abilities and experience that you need. Now, if the best fit on paper is the person that needs the sponsorship, you may have some difficulty.
Okay.
We might have an argument against that.
You may,
because,
yes.
Yeah, because the government might not accept that visa candidate.
Yes,
because you've got other candidates who have got the ability. They might not be as good, but they've got the ability to do the role.
Yes, because you've got to comply with immigration law as well as employment law. So where immigration law trumps employment law, I think you'd probably have a good defence. If that makes sense.
Yes, thank you.
Did anybody? Sorry, did I hear somebody else come in? Or
Yeah, I was just going to ask Liz. It's Ian here.
Yeah, hi Ian.
We've in effect got a broad brush policy of not looking for people that are needing visas, especially when we go to recruitment fairs and whatever at local universities and things like that. And in effect, we get asked on a stand, do you do sponsorships? And we tend to just say no, due to our size, we're not geared up for doing those sort of things and taking them through a process. I know it's quite easy to try and defend that if you're taking somebody on for 12 months and they're a student and they're probably here on a work stroke study thing. Yeah. To then turn around and say, you're potentially going to be with us for 12 months and it's going to take 6 months for us to get a visa. The things aren't there, but are we potentially at risk by stating that?
I think it's probably quite nuanced, and my gut tells me if you're going to recruitment fairs with specific opportunities that you're offering, and you are turning away people from other countries that say they need sponsorship, then I think you might be putting yourself at some risk. I think I'd probably want to pick up and talk to you separately about that though, Ian, and have a think about it with you. I think that needs just working through a little bit. Okay. Because at the end of the day, if the cost and the length of time is disproportionate, you should have a good defence to any claim. But as we know, candidates are desperate for opportunities, and we've been in this situation ourselves at recruitment fairs at local universities. Candidates come into this country who are using, they're studying, they're on graduate visas, they're desperate to get the work visa. So I'm just not convinced that if there's a specific opportunity that you are going to that fair with, and you're talking to lots of different people, and you're saying to the ones who would need a longer term visa, because they're probably on a student visa for now, aren't they? No, thank you, we don't want you. I think you're putting yourself at some risk. But I'm happy to pick up and have a separate conversation with you about that in a little bit more detail.
Okay, fair enough. Yep. Thank you very much.
Thank you, everyone. Thanks for your input and contributions today.
Super. Thank you all. Have a wonderful Christmas and see you in the new year. Happy
Christmas to you. Yep. See you in the new year.
Thank you.
Thanks. Take care, everybody. Thanks for attending.
Thank you. Bye-bye.
Bye-bye. Bye-bye.